Can you address the Civil Rights Act of 1964 and well, first of all, how did it come about?
So as I mentioned before, the 14th Amendment says that no state shall deny equal protection to anyone. However, that implies that the state governments should not deny equal protection. As I said, the states still segregated, but they called that separate but equal. The question of the 1964 Civil Rights Act is completely different, and it concerned whether private organizations, not the state, but whether private organizations could maintain segregated facilities or bar blacks altogether. So if we now understand that the states can't segregate on the basis of race, what about a restaurant? What about other types of public accommodations that are privately owned? That's a kind of a confusing term. An example of a publicly accommodating but privately owned facility would be a movie theater, a gas station, a sports arena, or a hotel, any place that the only barrier to going in is whether you have the money to pay for it. So this is an example of the type of segregation that was widely practiced throughout the United States. The 14th Amendment, as it is written, doesn't say anything about private ownership. So a hotel owner could say, no, I do not want to have black customers. A restaurant can say, I will take white customers in the area where there are tables, and a black customer has to take only from the back, only takeout. And this was widely practiced. The 1964 Civil Rights Act had to figure out a way to use the Constitution to force private businesses to take all customers. And what they did was they used the Commerce Clause and not the 14th Amendment. So I should explain this. Again, the 14th Amendment seems like the best vehicle for desegregation, except that it says nothing about private ownership. So Congress decided to go through its normal enumerated powers in Article 1, Section 8. In Article 1, Section 8, Congress has the enumerated power to regulate commerce between the states. Is a restaurant engaged in interstate commerce? You might think they're not. But where does the meat come from? Where do the tables and chairs come from? If you're in a movie theater, where does the film come from? If you're in a sports arena, where do the teams come from? If you're in a gas station or you're going to a hotel, maybe those things are engaged in interstate commerce, but so are the customers themselves. And the Congress decided to use all of these elements to desegregate private facilities, and the Supreme Court upheld it in a series of decisions starting in 1964.
Let's turn to the Voting Rights Act of 1965. Why was it passed, and what was its significance, and what is its current status?
So the 14th Amendment was not fulfilled until Congress decided to take action almost 100 years later. The same goes for the 15th Amendment. The 15th Amendment to the Constitution says that black men have the right to vote. Well, it doesn't say black men, but it's implied because women did not have the right to vote in 1870. It said that the status of a voter is not based on race or previous conditions of servitude. That's 1870, but we know that Southern and other states decided to have other types of laws that would effectively harm black enfranchisement. And that included poll taxes, literacy tests, and even something called the white primary. The white primary was an implication that political parties are clubs. And as private clubs, they can reject membership. And therefore, to participate in a primary, you have to be a member of a party. But if the party is closed, then the vote is closed. And that was very harmful because at that time in the South, the Democratic Party really only had vibrant primaries, not general elections. So for all those reasons, the Voting Rights Act decided to put attention to state laws and eliminate them.